Hello and welcome to CSG's webinar series. My name is Bryden Ross and I'm the Director of Energy and Environmental Policy at our headquarters office in Lexington, Kentucky. Today's event, the Clean Water Act and Waters of the U.S., will feature two prominent experts from the Army Corps of Engineers and EPA that will help state leaders unravel the complex legal issues involving the limits and scope of the federal regulatory jurisdiction over navigable waters of the U.S. and the Clean Water Act. In addition, the insight we can glean today from our speakers is especially timely in light of a potential federal rulemaking that may ultimately chart a path forward for states after two ambiguous decisions made by the Supreme Court. First, I'll introduce the first speaker, Stacey Jensen, who is a regulatory program manager at the headquarters office for the Corps. Her responsibilities include the Lakes and Rivers Division and the Pacific Oceans Division. And also she has jurisdiction over agricultural issues, compliance and enforcement, climate change, regulatory training courses, and the Army campaign plan. Stacey attended UCLA for both her undergraduate and graduate degrees, which are in ecology and environmental health science, respectively, and she's currently working on a doctorate in environmental science and engineering. Our second speaker will be Donna Downing, who is an attorney with the EPA's Office of Water, and she works on a host of wetlands-related issues with a focus on the geographic scope of the Clean Water Act in light of the Supreme Court decisions in SWANCC and Rapanos, which I referenced earlier in the introduction. Donna chairs the Federal Interagency Staff Working Group for implementing those court decisions, and she also serves as EPA's staff lead for Section 401 Water Quality Certification. She received her undergraduate degree from Harvard, a master's from UC Berkeley, and a JD and LLM in environmental law from George Washington University, where she served also as an adjunct professor for the GW Law School and EPA's Water Quality Standards Academy. So needless to say, we have a very impressive set of speakers with some impeccable credentials, so we're very fortunate today to have them with us. And I'll mention a few quick logistics points and we'll get started. First, all participants, again, I want to remind you, will be in listen-only mode, but we encourage you to submit your questions for the speakers as you have them. We'll have a question and answer session at the end of the presentations, and I'll read the questions aloud on a first-come, first-served basis. So just type those into your chat box here on the right to your screen. And I'll be happy to forward any questions you have once the webinar is concluded, if you have some, and provide them to the panelists as well, in addition to their contact information, where we encourage you to reach out to them directly. Lastly, I want to remind every folks our panelists won't be able to comment on internal regulatory deliberations on the potential rulemaking, so please keep your questions away from there because they won't be able to answer them. So with that, I'll turn it over to you, Stacey.
Okay, thank you very much, and thank you everyone for participating in this today. So as you can see, what we're going to discuss today is the Clean Water Act and the jurisdiction of the Clean Water Act in waters of the United States. It involves both the Corps and EPA, and we'll go into sort of the history a little bit and some of the important case law history, and then sort of our current implementation of waters of the U.S. In relation to some of those court cases. Next slide. So essentially what we want to say up front is that the current method that we're using for jurisdictional determinations is still the 2008 guidance that came out after the Rapanos Supreme Court case. That is what we should still be using. That is what people in the field need to be using. And we just want to make sure that we hit that point home that that is our current method that we should be using. Thank you. Next slide. Regulatory at the Corps of Engineers' mission is to protect the nation's aquatic resources while allowing for reasonable development through fair and balanced decisions. That's not just stopping at the aquatic resources part, which is a very important part of the mission, but we also have to have a challenging task of having to balancing that act with the reasonable development aspect. Next slide. So why do waters of the United States matter? These waters of the U.S. go under the Clean Water Act, various different sections of those and other laws as well. So we have 303, which deals with water quality standards and TNWS. Those can be implemented by states, tribes, EPA, or the Fish and Wildlife Service. 311 for oil spill programs is EPA. 401 state certifications can be states, tribes, or EPA. 402 for pollutant discharge permits is states and EPA. And Section 404 is for the dredge and fill permits, and that's the Corps, states, and EPA. Basically all of these fall under waters of the U.S. what those terms are under, quote, navigable waters. All of these sections apply to those waters. Next slide. What does the Corps do? Well, essentially, we administer the discharges of dredged or fill materials into jurisdictional waters under Section 404 of the Clean Water Act. We are the ones generally out in the field making a majority of these jurisdictional determinations. If an applicant calls up for a proposal, we're the ones that would go out generally to do to outline out the waters of the U.S., where they're located. However, having said that, the EPA actually oversees implementation of all of the Clean Water Act programs, including Section 404. They have specific responsibilities under their jurisdiction, and I'm going to pass it over to Donna real fast to talk about that.
Yeah, as Stacey indicates, EPA has responsibility for implementing all the Clean Water Act programs, many of them, by the way, in conjunction with states. And the Section 404 program identifies specific roles for EPA and for the Corps. The Corps is, as I suspect you all know, sort of the public face of the 404 program. But the Clean Water Act does, for example, indicate that EPA should be the one, in conjunction with the Corps, establishing the environmental considerations that the Corps will consider when it evaluates permit applications, the so-called 404B1 guidelines. But we also are responsible for determining the scope of waters of the United States, because it applies to all programs. There's a single definition for all those programs that Stacey spoke about on the last slide. And similarly, EPA under Clean Water Act is identified as overseeing program assumption of the Section 404 program by states and tribes. So it really is a collaborative program, but the Corps is sort of the public face of the day-to-day operations. Next slide. This is one of those slides with a lot of words on it, but there's a lot of ideas here. In a way, it is almost an outline of much of our presentation. It's not only a short history of Section 404, but also of waters of the United States itself. In 1972, Congress enacted the Clean Water Act and indicated that all its programs were designed to protect the navigable waters. And then in the Act, they defined navigable waters as meaning waters of the United States, including the territorial seas. And that's all the statute says about what waters are affected and protected and subject to all those different Clean Water Act programs. In the legislative history, though, Congress talked a certain amount about what it meant by this navigable waters means waters of the U.S., and indicated that they expected that it would be interpreted as broad as the Commerce Clause allows. In other words, as broad as the constitutional authority that Congress was using to pass the statute to begin with. That point came up early in a 1975 in NRDC v. Callaway, because when you have a term like this, that waters of the U.S., it's not specific enough, so the Corps and EPA write regulations that give additional detail consistent with what the statute says. And in NRDC v. Callaway, the court felt that that a decision that initially, I believe in a Corps regulation, that waters of the U.S. was navigable waters, similar to waters that are protected under another of the Corps' authorizing statutes, the Rivers and Harbors Act, wasn't broad enough. The term is broader than merely waters that are navigable. So as you can see here, I'm not going to go through each of the years because we'll be here for years, but there are, when the agencies issue regulations to provide additional clarification for a key statutory term, it's very common that we go to court and we get additional clarification, and this term is no different. In 1985 was the first time that the Supreme Court of the United States received and accepted a question, what are waters of the U.S.? And that was a question as to whether or not wetlands that were adjacent to a traditional navigable water were properly considered a water of the U.S. And that's Riverside, Bayview homes, and we'll talk a bit more about that in a moment. When you have a statutory term that isn't laid out in great detail, like navigable waters means waters of the United States, and the regulatory agencies issue regulations with additional clarity, we often say additional things about what that term means in preamble language that precedes a new regulation or a restatement of a regulation in the Federal Register. And that happened here too. In 1986 and again in 1988, the agencies discussed in preamble language what we thought Congress had in mind when it said broad as the Commerce Clause allows, and gave 3 examples. One was used by migratory birds. Another was the presence of endangered species. And the third was use of those waters by irrigated agriculture to grow crops that are sold in commerce. And even though those aren't regulations, and it's not all about birds, in about 3 seconds, that became known as the Migratory Bird Rule. That became a little more prominent in 2001 on our second visit to the Supreme Court in Solid Waste Agency of Northern Cook County, which also we'll talk about in more detail in a moment. But that addressed the question of isolated waters, waters that aren't nearby or adjacent to the tributary system or a traditional navigable water. Following SWANCC, there was an advance notice of proposed rulemaking where the agencies sought information about sort of the nature of the aquatic ecosystem out there, the extent of certain kinds of waters, and what people thought about policies, and ultimately did not move forward with the rulemaking. Once again, back to the Supreme Court in 2006 in the Rapanos and Carabel cases, which involved adjacent wetlands and their tributaries. And that will be the third of the cases that we touch on here in a moment. Since then, as Stacey will go into greater detail near the end of the presentation, the agencies, as we very often do when a key term is interpreted by the Supreme Court, issued guidance to explain to our field staff and the regulated community what waters of the U.S. means in light of those Supreme Court decisions. Because the Supreme Court decisions in SWANCC and in Riverside, and in Rapanos did not invalidate those regulatory definitions that the Corps and EPA have, which are the same, for what waters the United States means. But it affected how we applied them, so we put guidance out. And as Stacey emphasized at the top, and will emphasize at the end, the guidance that's currently in effect on how to interpret our regulations in light of the Supreme Court is that December 2008 guidance. And as you'll see is the last bullet, and hear more in a moment, we have been working on revised draft guidance in light of sort of field experience, U.S. Court of Appeals, and the like. And we'll talk a bit more about that as well. But first, next slide, and I'll pass it back to Stacey.
So this slide actually depicts what core regulatory jurisdiction is all about, but it doesn't just hit this part of discussion of the Clean Water Act for Section 404. It also mentions some of our other authorities that the Corps has jurisdiction over, Section 103 for ocean discharge of dredge material, and Section 10 of the Rivers and Harbors Act for all structures and work. So you can see from the little depiction, there are different outline boundaries for each of these authorities. So Section 10, you can see goes up to mean high water. You can see a little guy on the little pier fishing. So Section 10 authority goes up to the mean high water boundary, whereas Section 404 under the Clean Water Act actually goes beyond that to high tide line. And you can see that both in the coastal section on the left side part of the slide, and then on the right side you have more of a freshwater system indication, and in those we use the term ordinary high water mark for Section 10, and 404 actually extends as well into wetlands adjacent to those waters. Next slide. So as Donna mentioned, we do share the same definition for what waters currently are with EPA, and that is defined as traditionally navigable waters, interstate waters, waters that could affect interstate commerce if used, degraded, or destroyed, impoundments of jurisdictional waters, things like dams, tributaries of jurisdictional waters, territorial seas, wetlands adjacent to jurisdictional waters, and this does exclude by our regulations that waste treatment systems as well as prior converted cropland, which are tricky issues themselves, but we're not going to go over today. But those terms can sometimes be ambiguous. What do some of those mean? And they can also differ from what you may see in scientific articles. So some of the terms that you may see instead in those kind of articles are things like perennial or intermittent or ephemeral streams. They also, wetlands can be mud flats. They can be playa lakes, prairie potholes. You can have vernal pools. There's a lot of different terms that you'd see out in the scientific community, that may not be, you don't see them on this list, but that doesn't mean that they're not included as waters. They're just a little bit different terminology that gets used. Next slide. So I'm going to turn it back over to Donna to go over some of the case law history.
Okay. The regulations that the previous slide indicated, the EPA and the Corps have the same definition. We co-administer this program as well as the Clean Water Act as a whole, because again, there's one single definition of waters of the U.S. for all Clean Water Act programs, with the exception of the exemption for prior converted cropland. These regulations really haven't changed at all since about 1977. And it took a few years, but in 1985, off we go to the United States Supreme Court, where the question was whether or not wetlands that were adjacent to a navigable water that was actually supporting commercial watercraft considered to be quote-unquote navigable. There was some discussion, that you get greenery stuck in your propeller. How can it be navigable? And in a unanimous decision, the U.S. Supreme Court said yes, wetlands were properly considered a water of the United States when they were adjacent. And the opinion talked about the integrated nature of the aquatic ecosystem. And they did, however, say, we're just talking about wetlands that are adjacent, near, neighboring, bordering, or contiguous to this traditional navigable water. Isolated waters, waters that are farther away, we'll reserve for another time. So we felt pretty good for quite a few years, and we'll see when 2001 comes. But next slide. As I mentioned, the migratory bird rule is neither a rule nor entirely about migratory birds. It's language in the Federal Register preamble that preceded a reordering and consolidation of regulations in 1986 and again in 1988 that the agencies provided to give a sense of what we think Congress had in mind when they said broad as the Commerce Clause allows. And as you can see here, it involves use by migratory birds or endangered species or the use of the waters for irrigated crops that are then sold in commerce. And if you go pull out our Code of Federal Regulations, look for the migratory bird rule, you won't find it. What it's doing, that's why I emphasize it's preamble language. It's not a rule. It's interpreting how do you take into account that part of the regulation that Stacey paraphrased. The waters of the U.S. include waters that could, that if degraded or destroyed, could affect interstate commerce. So the migratory bird rule was giving more examples of those. Next slide, please. In 1985, we were feeling pretty good about a unanimous decision in support of our regulations in Riverside, Bayview homes. In 2001, that little aside the Supreme Court had that we're not talking about, those more remote, geographically remote waters, came to rest in the Solid Waste Agency of Northern Cook County case, which arose in Northern Cook County, Illinois. And there, the Corps of Engineers had asserted that the ponds and areas that were left over from gravel mining of decades earlier that had turned into the second largest great blue heron rookery in northern Illinois were jurisdictional based on presence of migratory birds. In other words, the migratory bird rule. And the Supreme Court in SWANCC said no, that it is not appropriate to say something's a water of the U.S. based solely on the presence of migratory birds, that you need more. And they said, well, the Clean Water Act intended some connection to navigability. In the 1985 case, Riverside Bayview Homes, where they upheld that adjacent wetlands were part of waters of the U.S., the Supremes had also said the word navigable is of limited import in the Act. The SWANCC Court, which had some of the same justices on it, said saying that navigable is of limited import doesn't mean it's of no import. And the Clean Water Act and Congress intended some connection to navigability. And they also pointed out that they were interpreting the definition of the Clean Water Act for navigable waters, meaning waters of the United States, including the territorial seas. So even though this was a Section 404 dredge spill permit case, it had and has implications for all Clean Water Act programs. And the end result of that is the Corps and EPA and any other of the Clean Water Act programs can't regulate isolated waters based solely on the migratory bird rule. Interestingly, even though SWANCC was 404, and often incorrectly I think, the 404 program is thought of as the wetlands program, SWANCC didn't involve any wetlands. It was all these geographically remote, isolated ponds. Next slide, please. This is a fairly busy slide showing you all the fun questions that began to arise after the SWANCC decision came down. We also, by the way, had, I believe, 40 federal district and appellate court decisions trying to interpret what SWANCC meant. We all know that it said no migratory bird rule. That's the easy part in the upper left of this slide. But there were questions of, did it change the assertion of over, say, tributaries, or how about adjacent wetlands? Or was it just focused on these geographically more remote, isolated waters? And virtually all of those cases said yes, it was focused just on those more geographically remote, isolated waters. 2 of those cases, though, as we'll see in a moment, came back up to the Supreme Court. But first, let's look a bit more at the type of issues that come up in this slide. One of the questions is, what's isolated? And so as you see here, you have adjacent wetlands. Is it based on how close you are, or is it hydrology? The SWANCC court didn't really say. But it's a question that as you implement these things, you begin to wonder. You'll note that there's also says groundwater. Waters of the United States has been interpreted by the agencies, as well as every court that's addressed it, as being a surface water statute. While groundwater might serve as a connection for a water to the tributary system, groundwater itself is never a water of the United States. But this can give you an idea, and it's animated, as are our field staff, as they try to implement this confusing term after the SWANCC decision. So next slide, please. I mentioned that we had an avalanche of federal district court and U.S. Court of Appeals decision, 19 U.S. Court of Appeals decisions, which is pretty remarkable for a single term. And I think you need to click in order to get the text for the slide. Very good. And there were 2 cases, both arising in Michigan. One of them only about 3 miles from the Riverside Bayview home site that had gone up to the Supreme Court in 1985. So Michigan's feeling a little bit focused on, shall we say. One of those was the Rapanos versus United States case, where the question was, is it proper to say something's a water of the U.S. if it has a surface hydrologic connection to a ditch that drains into a traditional navigable water? There was a second case that came up, which will show up when someone clicks, very good, which was the Caravels, who were wondering if you had a wetland that was adjacent to from a tributary, but separated by a man-made berm. Essentially what had happened is someone had dug a ditch, a fairly large ditch, but had side-cast the material to the side, thus creating a berm between it and the rest of the wetland through which the ditch had been made. So the question was, how far did this concept of waters of the United States extend? And I think it's safe to say that nobody got what they were hoping for out of the Rapanos decisions. I call it Rapanos because the courts had oral arguments in both cases at the same time, issued a single, well, I was about to say single opinion, but you'll see that's wrong in a moment and why. They addressed both cases, and they're now sort of consolidated and thought of as the Rapanos case. So the Caravels aren't talked about quite as much as Mr. Rapanos. But next slide, and we can see what happened. This, by the way, was the first day that Justice Alito was on the bench, and it was about 23 degrees outside the night before. This matters because there was about 400 people in line all night to try to get in to sit in the 50 spaces that are open to the public to see this particular case. That's because of the importance of the case. Essentially what was being litigated was, does the Clean Water Act and its programs protect waters beyond those that are themselves supporting commercial navigation and wetlands adjacent or not? There were several hundred people who signed on to what are called Friends of the Court briefs that are submitted to give additional information for the justices to consider. they considered, and as I mentioned, they didn't get what they were hoping for, just about anybody. There is no majority opinion. You can't say this is what Rapanos held. We had 5 opinions from the 9 justices, and none of them have the 5 votes necessary to be considered the majority and thus the decision. So it's a 4-1-4 split court. There are, and by the way, it was remanded or vacated, as they say, overturned and sent back down to the Court of Appeals for consideration. There were 3 opinions that came from the Rapanos court that are a particular focus. We'll talk about 2 of them beginning on the next slide, please. The first one is the Plurality, authored by Justice Scalia, which said waters of the U.S. extend to waters that flow, that are tributary to traditional navigable waters that flow at least seasonally. What he said was if it's a relatively permanent water, and then dropped a footnote saying he means waters that flow at least seasonally, even if they dry up in times of drought. And with respect to wetlands, wetlands with a continuous surface connection to these relatively permanent waters are waters of the U.S. And so the Plurality, with a total of 4 votes, say you pay attention, and if it's relatively permanent or flowing at least seasonally, then you have a water of the U.S. Justice Kennedy agreed with the Plurality that the decision below should be overturned and sent back down and thought about by the appellate court, but did not at all agree that the reason was whether or not it was relatively permanent. He said the question you need to think about isn't relative permanence. Instead, you have to think of the significant nexus between the water you're wondering about and a downstream traditional navigable water. And as you see here on the slide is essentially what he said he thought significant nexus meant. And that's when the water that you're looking at and trying to decide if it's a water of the U.S. is a water of the U.S. if either by itself or in combination with similarly situated lands, one thinks he probably meant waters, in the region significantly affect the physical, chemical, and biological integrity of those downstream waters. In other words, what's the relationship between the two? As the SWANCC court said, there's some connection to navigability. In Kennedy's eyes, it's because the water upstream that you're wondering, is it a water of the U.S. or not, has that significant nexus to the downstream traditional navigable water. The third opinion was by the dissent, also 4 votes, authored by Justice Stevens, where he said that EPA and the Corps got it right. Kind of like that opinion, but nonetheless, the government knows that Rapanos decisions happen, and what, as you'll see when we talk about the guidance currently in effect, agree, consistent with Supreme Court jurisprudence, when you have a split decision like this, 4-1-4, that without taking you all to law school, the result is that something is a water of the United States if it either is relatively permanent or has a significant nexus. And that is where the majority of U.S. courts of appeals after Rapanos has gone as well. Let's look a little more detail at what the opinions say from Rapanos with the next slide, please. This is a bit more detail on that relatively permanent waters plurality standard authored by Justice Scalia. If a water is relatively permanent, if it's perennial, flows primarily throughout the entire year, and other waters where the flow is at least seasonal. For example, 3 months. In other areas, seasons may be longer or shorter, are considered relatively permanent waters. And as we mentioned, the plurality said wetlands with a continuous surface connection to relatively permanent waters are also waters of the U.S. And the way that the agencies, as we'll see, have interpreted that is that means that the that the wetlands abut the relatively permanent waters. And as you can see here, it's laying out what the post-Rapanos guidance, that guidance that's currently in effect since December 2008, indicates. So these are the ways that the agencies are interpreting the plurality test, one of 2 ways that something can be a waters of the U.S. Next slide. Kennedy talked about significant nexus, a phrase that scientists will be quick to tell you isn't easily found in the scientific literature, but the determination if something has a significant nexus is based on science. And there you evaluate the flow characteristics, the functions, the ecological relationships of the tributary in combination with functions of the wetlands that are adjacent to it, and how that affects the downstream integrity of the traditional navigable water. In other words, if there's a significant nexus. Now, Kennedy didn't talk very much at all beyond that phrase, alone or in combination with similarly situated lands in the region, what he meant about significant nexus. But he did say, in order to have a significant nexus, you have to have sort of an indication that there's more than an insubstantial or speculative effect on that integrity of the downstream traditional navigable water. So next slide, please, and I'll turn it back to Stacey.
So just looking at it sort of in a diagram or picture view, what waters would be involved in these cases that we've discussed? You have, didn't show up on this one, Rapanos. Rapanos would be involving the adjacent wetlands and, thank you, non-TNW tributaries, so non-traditionally navigable water tributaries. So you can see the extent to which Rapanos covers those waters that are in question in that case. Whereas SWANCC, we discussed, is really about those other waters, those ones that are far removed, the isolated geographic waters. And then you have Riverside, Bayview, Homes, which discuss the adjacent wetlands to the TNWs. So you can kind of just see from a representation of sort of like a topographic view what areas these court cases covered. Next slide, please. So now we're going to discuss some of the categories that we have talked about. What are these waters of the U.S.? And we've added some pictures so you can just sort of, sometimes it's easier to pick it up sometimes, the idea just visually. So we have traditional navigable waters, which I think everybody probably understands generally what that means. So we have a Pacific Ocean, obviously, and the Yellowstone River. Those would be considered traditional navigable waters. And those are waters of the United States. Next slide. Then you have the wetlands adjacent to the TNWs. So this was one of the ones discussed in Riverside, Bayview. And you have things such as wetlands in the Pacific Ocean. Those would be salt marshes or coastal wetlands. You've got Mississippi River ones. That one you can see is connected actually via pipe to the Mississippi River, and that can lead it still to being claimed as adjacent wetlands. And then you have the next one, a picture of the Mississippi River, and you have a man-made barrier that's separating it like a berm, separating that wetlands from the navigable water, but it's still considered adjacent. Next slide. Now we get into some of the other terms that are more of a legal aspect. We have relatively permanent waters. Now these can be waters such as perennial waters, so those are streams, rivers, whatever that flow year-round. And you have those seasonal waters, which came up a bit in the Rapanos decision as well. And those can be things, those are considered like intermittent waters. That could be the scientific term that you're more familiar with. So these relatively permanent waters are actually jurisdictional under the Clean Water Act, post-Rapanos, as our guidance says. But as a matter of policy, the Corps will still include in the administrative record all information that pertains to the existence of a significant nexus between the TNW and an RPW that's not perennial, so intermittent. And that's just as a matter of policy. It's not required by law. We just like to have that in our administrative record to show the strength of that connection. Next slide. Wetlands directly abutting these RPWs that were mentioned in the previous slide. You have this pretty picture of Alaska, unnamed water and wetlands, and that shows that those wetlands do directly abut, meaning they're essentially touching that water. And then you have the next picture from North Dakota, same aspect. You have the river that goes through the middle, and then you have those outlines of those abutting wetlands. And these are wetlands directly abutting, these RPWs that flow directly or indirectly into a TNW. Those are jurisdictional under the Clean Water Act. Again, as a matter of policy, the Corps actually includes in the administrative record any documents for the existence of a nexus, significant nexus for a wetland directly abutting an RPW that is not perennial. So again, administrative policy only, not required, but we do like to demonstrate the strength of that connection for a wetland directly abutting a perennial, so that would be like an intermittent stream. Next slide. So what about wetlands that don't directly abut the RPW? So these are wetlands that are separated. They're not directly touching. They flow to the RPWs, and these RPWs then flow into or indirectly, directly into the TNWs. Those are jurisdictional, again, under the Clean Water Act when there's a significant nexus with a TNW. So that is very important. This one actually is required. It's not as a matter of policy. We do, under the guidance, have to document this, document the significant nexus. And again, it's the significant nexus of the wetlands that directly abut the RPW that flows to the TNW, but it's that nexus from the wetlands to the TNW. It's not a nexus between necessarily the wetlands and the RPW. You actually we have to prove and show that these wetlands actually have some form of significant nexus to the TNW. It's affecting the physical, biological, or chemical properties of the TNW itself. Next slide. This one discusses non-relatively permanent waters. So these are things in the scientific community you generally see as ephemeral tributaries. So you can see a couple examples, photos on this. The one on the left is from an unnamed ephemeral tributary in Idaho. And often these do have no name. You won't see them necessarily on the topographic or USGS quad map. They may not show up on those. They may not have, you know, an actual name. Doesn't mean that they're, you know, not important or function sometimes. So we then, on the picture on the right, have an ephemeral tributary from the desert out in California. So, you know, you kind of look at that, and it's hard to even sometimes understand why that's, you know, waters of the U.S. or so that is part of why we have to do this significant nexus determination for non-RPWs as well. And again, it's their nexus to the TNW that we have to prove, that significant nexus. So, you know, showing this ephemeral tributary, what effects does it have on the physical, chemical, biological properties of that navigable water that you can see in that photo? I'm assuming that that's a TNW. If it were, that's what you would try to show, to document in our administrative record. Next slide. Similar as the wetlands adjacent prior to RPWs, now we have wetlands adjacent to non-RPWs. And these, again, are going to require that significant nexus determination to prove and show how it's affecting the physical, chemical, biological properties of the TNW. So you can see there are two photos, adjacent wetlands. One's in Arkansas, and one is in SAD, which is our South Atlantic Division, which includes areas like Florida. So again, that one's going to require, if it's a non-relatively permanent water, so say an ephemeral tributary, these are wetlands adjacent to those waters, proving the significant nexus, showing it with a TNW itself. Next slide, please. So besides these jurisdictional waters that we've just mentioned, there are certain features that we generally do not include as jurisdictional waters. And these ones include swales, erosional features like gullies. Those happen a lot out west in the arid west areas. Small washes that generally have low volume. They're infrequently flowing, short duration, generally, you know, only maybe after a precipitation event for a short period of time. Also things like farm ponds are also generally not considered jurisdictional waters, farm and stock ponds. Ditches, including roadside ditches, and these include ditches that are excavated wholly in, draining only uplands, and do not carry a relatively permanent flow of water, so more like an ephemeral flow ditch, and they have to, again, be excavated out in the upland. So if you excavate a ditch out of a waters of the U.S., that is still going to remain a waters of the U.S. Another feature that's generally not jurisdictional are uplands that transport overland flow from precipitation. Also waters that do lack a significant nexus if one is required. So the ones that we've discussed, like those non-relatively permanent waters that require a significant nexus determination, if a water fails to make that significant nexus determination, fails to meet it, then it would be a non-jurisdictional water. And lastly, again, as we discussed earlier in the presentation, regulation excludes jurisdiction over waste treatment systems as well as prior converted cropland, which is a term that the NRCS USDA uses. Next slide, please. So these are just some photos of what some of these non-jurisdictional features may be. You have some ditches in the middle there. You've got some erosional features on the right, and a swale on the left. So those are considered generally to be non-jurisdictional. You may see those common out in the if you're out in the field a lot. And again, these happen quite often in the arid West. Next slide, please. Then we discussed the SWANCC case. Those other waters include these isolated waters and wetlands, and essentially for these isolated waters, the staff in the field will need to make case-by-case determination on the jurisdictional status of the resource. And these actually have to get routed up through headquarters here, and you need headquarters concurrence before you can make that final determination call if you are claiming an isolated water as jurisdictional. So essentially, if you're looking out in the field and you know all about SWANCC and you're supposed to use that information, but sometimes in a case-by-case determination, these waters may still not be considered as isolated and they may be jurisdictional then. Next slide. Now I'm going to pass it back to Donna.
Okay, as I mentioned, the Supreme Court in SWANCC or in Rapanos didn't invalidate the regulatory definition that the agencies developed for the term waters of the United States, but it affected how those regulations are implemented. You now need to look, for example, in many waters if there's presence of a significant nexus, or is it relatively permanent in terms that just don't appear in the regulations. And I imagine at this point, for those who are coming new to the waters of the U.S. issue, your head's spinning. That's often found with people who work in this area quite a lot as well, because of the fact that terms that now are the legal basis for deciding something is or isn't a water of the U.S. are not directly used in the scientific literature. So the agencies and the regulated community look to the scientific literature and the science and what you see on the ground to see if the characteristics of a particular water meet the legal standard as laid out by the Supreme Court consistent with our regs. So does it have a significant nexus? Is it relatively permanent? Gets you much of the way, but not all of it. There are some key terms, though, that have become increasingly important as a result of the Rapanos and SWANCC decisions, such as what exactly is a tributary? What is this significant nexus? Kennedy raises the issue and indicates that it's a basis for finding something to be a water of the U.S., says it needs to be more than speculative or insubstantial, but doesn't say more. Our regulations, because among other things they predate Rapanos, don't define significant nexus, and many have encouraged us to move forward and do so. Similarly, Stacey laid out a variety of non-jurisdictional waters. The regulations do identify two exclusions from the definition of water of the U.S., one for waste treatment systems and the other for prior converted croplands, which is a term from the Food Security Act that the U.S. Department of Agriculture uses. But there are other features that historically have been considered non-jurisdictional that Stacey discussed that are not reflected in the current regulatory definition and its exclusions, and many have suggested it would be helpful to list those as well. So even though they're not invalidated, there are difficulties with the current regulatory definition that EPA and the Corps have for waters of the U.S. Next slide. These are a couple of statements illustrating sort of the, at this point, relatively long, lengthy concern that folks have had about issues of waters of the U.S. and clarity. Candidate Obama indicated, for example, as far back as September 2008, that he is troubled by the recent Supreme Court rulings, which were, by the way, Rapanos and Carabel. Now, those two decisions were construing the meaning of the statute, the Clean Water Act, and not the meaning of our regulations as much. And so as a result, Stacey and the Corps of Engineers, me and EPA, can be involved in revising regulations, but we can't revise the statute. So in May 2009, the heads of the Council of Environmental Quality, EPA, Agriculture, Army Corps of Engineers, and U.S. Department of Agriculture, Interior, all wrote a letter to members of Congress observing that Rapanos, in effect, created a problem, and that although the agencies can address many of those problems through rulemaking, that legislation is necessary for a complete fix, again, because the decisions were in construing what the statute meant. It also emphasized the importance of the Clean Water Act and its broad protection and its importance for economic and aquatic ecosystem benefits that were at risk because of some of the ambiguities from the decision. Next slide, please. There's a variety of actions that the agencies are doing, and we'll talk about over the next couple of slides. But the goal of these administrative actions that we can do, obviously agencies don't do legislation. We provide information to Congress should they choose to legislate. But we can issue alternative or updated guidance. We can propose regulations for public comment and go final on them. And what we're looking at is the array of possible administrative options that we have, and with the purpose being the idea to clarify the scope of waters of the U.S. in light of SWANCC and Rapanos and consistent with current science, so that we can be as specific as we can be in light of the Supreme Court decisions and what science has to offer us in terms of how to define some of these key terms I mentioned. Why do we need it? There is concern about inconsistency of interpretation. It's a big country. There are 38 core districts, 10 EPA regions, a lot of jurisdictional determinations being made in the 404 program alone, but also this term applies to all those other Clean Water Act programs as well, the Section 402 pollution permit program, the 311 oil spill program, and so forth. And so consistency of interpretation is desirable, but also more clarity to reduce confusion in the regulated community about what is a regulated water or not. When do I need to address and be involved with these Clean Water Act programs? So hope to improve predictability by having consistency and clarity, efficiency, and moving forward that way. So with that, I'll pass it back to Stacey for a bit of information on data we have as to what's been happening since the Supreme Court decisions.
Okay, next slide, please. So as you can imagine, since the Corps does a lot of jurisdictional determinations, we also have a lot of data from those. We actually reviewed after Rapanos from our fiscal year 9 and fiscal year 10 data. We reviewed them to determine how many waters in our database are now non-jurisdictional after the Rapanos as well as the SWANCC decisions, and then our guidance that came out after those decisions. So out of 184,000 waters that were reviewed in this data call, 8.2% were determined to be non-jurisdictional under either the Rapanos or the SWANCC guidance. And of those non-jurisdictional waters, 0.6% were non-jurisdictional due to a lack of significant nexus under the Rapanos. 4.5% were isolated under the SWANCC, and 3% were various other options of why it would be non-jurisdictional, some of those other features that we discussed. Next slide, please. So now we move on to what are we doing now? Our current agency actions. In May of 2011, joint EPA and Corps proposed draft guidance to help clarify where the Clean Water Act applies, sort of to do some of that purpose and need, as Donna discussed in a few slides ago. July, the public comment period for that guidance closed. We did receive many comments. Over 230,000 comments were received.
Addressed to me.
Donna had her mailbox was full. And we did receive many of those comments that requested us to pursue rulemaking as opposed to just drafting this guidance. In its current state, the final draft guidance, still in draft form, again, not to be used by the field or anyone else for that matter. The 2008 Rapanos guidance is what should be used right now. The final draft guidance was sent to the Office of Management and Budget for interagency review. Again, it is still currently in draft form.
When the agencies put out the draft guidance for public comment in May 2011, one of the things we indicated at that time was that it was our intent to do guidance and also explore what additional advantages there would be from rulemaking, that the agencies intended ultimately to do rulemaking on this issue, which is probably one of the reasons why I think something on the order of 90% of the comments that we received on the guidance were supportive of either in addition or alternatively doing rulemaking. And the agencies continue to be exploring rulemaking as well as guidance.
Yep. But it's therefore it's still in draft form, the guidance, and we have not proposed a rule as of yet. So next slide. Again, as stated, the Rapanos 2008 guidance is still the current method for JDs at this time. Now we are open for questions. If anyone else has any, go to the next slide and you can see our contact information for future questions you may have after this webinar. Feel free to contact either myself or Donna or both. We're both the ones working this issue for the Corps and EPA. Does anyone have any questions online now?
Let's see. Yeah, I think we're going to submit them online, and then they were going to be coordinated by our host.
Okay.
Yeah. Hold on. I think we have one coming in right now. Hold on here. Okay. Is the database of JD, the jurisdictional, hold on, sorry. Is the database of jurisdictional waters available to the public, or is that an internal database?
That is our internal database that we use to keep track of all of our project files and applications received. It's called ORM, On-Bill Regulatory Module. It's a lovely acronym. But we do get many FOIA requests for data all the time, and all of it technically is releasable. We just need to do a little bit of digging. But because of Rapanos and SWANCC and this decision with the proposed guidance, as well as just kind of wading into whether we want to do rulemaking or not, we have done a lot of those that analysis already. So we do have some of that data.
Also, I think many, if not all, Corps districts put their jurisdictional determinations up on their website for at least a quarter. Some districts keep them up longer than that, but it becomes an issue of sort of server size, because many times they come with very detailed maps and other information that helped inform the decision. So if you were looking for examples of jurisdictional determinations, check out your local Corps website and you'll likely see quite a few. Similarly, EPA and the Corps have at headquarters a website that includes sort of where jurisdictional determinations were elevated to headquarters for discussion, various memoranda that we issued jointly to resolve the question with the JD, and those are posted. I think, frankly, they're most readily found on the Corps' website. Mm-hmm. So those are other places that you can go to as well that are publicly available.
So those include the waters that, as I went through, some of those waters that require the significant nexus determinations, or isolated waters that may be claiming as either jurisdictional or not. Those are the waters that then, the determinations that then have to get coordinated through headquarters, EPA, and the Corps. And as Donna mentioned, some of those do get elevated at the headquarters level, and that needs to have, it basically means that headquarters will make the final determination.
Okay. You mentioned earlier in your presentation about with the lack of sort of definition of these legal terms of art on significant nexus and the like. A lot of these regulatory determinations and permits are made on a case-by-case basis. Could you shed a little light on how that's done in terms of because Congress didn't really define a lot of these terms and these court cases didn't settle these other legal terms? How do you do that as an agency?
Actually, in the decision, there are a few examples of things that Kennedy, especially in his decision, mentions that we could use to look at for a significant nexus. And again, we're looking for the physical, chemical, and biological properties. So if our PM goes out in the field and has to do a significant nexus determination, oh, sorry, I'm so used to saying that. If a project manager goes out into the field to do a jurisdictional delineation out there and needs to make a significant nexus determination, they're going to look for clues that basically are going to provide evidence of whether that significant nexus to the TNW exists, related to physical properties, chemical properties, biological properties, so things like regarding species, movement, perhaps migration of even from frogs and such. Salmon, yeah, for big stuff. So sediment load, pollutant transfer, all sorts of things that they can look at in the field, as well as gather data from other sources that they know about the area. There's a lot of different areas for evidence available to the project manager.
As we mentioned earlier, the agencies and many U.S. Court of Appeals believe that something could be jurisdictional if it meets either the Kennedy standard, significant nexus standard, with where you'd consider the factors that Stacey was just laying out, but also if it's relatively permanent. And you might look, for the example, in the field, if you're wondering if a water is relatively permanent, if you see large fish there, it's possible, particularly if there's not a ready route for them to easily commute down into the navigable water, that may be an indicator, along with other factors, that it is relatively permanent. There's also various field standards that are widely used, not just by EPA and the Corps, but universities and states, that help when you're looking at a particular water body to help determine if it's ephemeral, flows only in response to rainfall or snow, or if it's intermittent, where it's seasonal and has sort of a groundwater contribution, or if it's perennial, and you would look at things in, those kinds of factors. If you're interested in seeing how some of these play out, I really would encourage you to go look at some of the draft, the jurisdictional determinations that are on the website, because that will include the form that's typically used by the project manager in the field to sort of document what factors they're seeing and what led them to either conclude that it is or is not a water of the U.S.
Right. So if you have a particular area in mind, you should go to your figure out which your local court district office is, and you can go on their website and view those JDs. We also have other documents. The Corps has engineering research department, ERDIC, and they're based out of Vicksburg, Mississippi, but we fund them to do a lot of different research projects for us that really help us in our day-to-day job. So one of them, for example, they do an arid west delineation manual that was very helpful, because as you can imagine, the arid west is one of the most challenging areas for us to be determining jurisdiction. So that arid west manual really helped the staff and the project managers. They got trained on it, so it really gave them better understanding of their environment in that area. And those are also on Corps headquarters websites, a lot of those manuals and things that we have had our ERDIC provide us.
There's also, I mentioned the jurisdiction form that Corps field staff in the 404 context typically use as they're gathering information about a particular water body and making a determination if it's a water of the U.S. or not. That form's online at the same website as some of the memos, the elevation memos as we call them. But also there's something called the instructional manual, and that's a manual that says how should you use this form. And you might find, if you're wondering what do people look at when they're in the field, that to be helpful. You'll also see that's a source of several of the pictures that Stacey used to run through the different kinds of waters in the U.S. after Rapanos.
Okay, well, I don't see any more questions in the queue, but I think that's a result of our speakers' mastery of the topics and your very informative presentation today. I think you probably eliminated most of the questions that they would have.
Very good.
We would encourage those who have more questions. You can always send them to me at bross@csg.org. But also, I'd encourage you to reach out directly to our presenters. This is one of the great resources of the webinar. You get to talk to experts who are much more have much more in-depth knowledge and expertise on these issues than we do here. So we encourage you to reach out to these folks at the Corps and EPA. And we should have this up on the website probably early next week. But again, we'll have the slides online as well with the Q&A. And again, I really want to thank our speakers today. Stacey and Donna, you were great. And all on the line, you all have a good afternoon, okay?
Thank you very much.
Thank you very much for the opportunity to talk with you all. We enjoyed it.
Yep, we did.
Okay, thanks so much.
Thank you. Bye.
Bye. Bye-bye.